Listen, I'm going to define it for you. And this definition is actually coming from the Kenyan Constitution. Someone asks you, what is marriage? There's a specific definition of that act according to law. You gotta go all the way back to the Marriage Act 2014 of Kenya for you to really know where these definitions are coming from. But just to read it before I introduce the guest that is going to join us, so we can talk about the big conversation this morning. Listen, it says that it is when two adults, that is any other person is above 18 years of age, according to Kenya, then decides to marry one another. Regardless of how you do it, the law also factors in even religion and the culture and all that. But then there's that thing that ties you to law, that indeed, under the auspices of the church and the Kenyan courts, you have then conformed to be husband and wife. Only that. Then the rest of the questions then begin. Because I want to take you back to two rulings that are landmark, and I'm going to avoid the next one for the second part of this conversation. But then this is what it says then, and I would like to read it for you. Can we stay? Which up to early this year was a thing, where indeed if you stayed with somebody for 6 months, according to the Kenyan law, that person could essentially have claimed to be either your wife or your husband. And if they prove indeed that you have cohabited together for 6 months, then you can run away from that. But then a landmark ruling was made that reverted all this. That's what we're here today. We're calling it Come No Stay. Court quashes the temporary marriages that you guys have been running on in the country for quite some time now. Now to join us to talk about this ruling and many other things that you need to understand under the Marriage Act is Mercy Mueni, who is an advocate and a family law practitioner. Mercy, how are you doing?
I'm good.
Conversations like this.
Yeah.
I know you're a law practitioner.
Yeah.
But every time you talk about issues like this, you have to try as much as possible to remove the legalese conversation out of it and make it easy for any other person to understand.
Yes.
Let's go back to before this ruling again that we're talking about here today. What informed the ruling before this current one that essentially changes also a couple of clauses in the Marriage Act?
One thing you need to understand for any legal practitioner, this is nothing so new.
Are you doing that?
Yes. There's nothing new because with our Marriage Act 2014, it is well laid out on what our marriage is and what our marriage is not. Then there's a lot, what actually the Supreme Court has done is even opened the box for the presumption of marriage rather than even closing, because now it's giving the judges the discretion to look at every circumstance, and the Supreme Court went ahead to give elements that lead to a presumption of marriage. So if a party is able to convince the court that you've met all these elements, and one of the elements is of course intention of parties, is their intention, is their consent, long cohabitation, and a repute. That is, people presume you people are married. So it opened the Pandora, which I think also social media and medias didn't really get it.
Yes.
Yeah, it didn't really get it.
Yes.
The Supreme Court just opened that box and gave the judges the discretion, and even made recommendation to our legislators and even the AG to make those recommendations, where we also have our Marriage Act defining what is a presumption of marriage, because we just have like section 2 of the Marriage Act defining what is cohabitation.
Yes.
What is to cohabit, but it doesn't go further to like give what are the elements, because one of the problem we can say the ruling created is when it laid the elements, it also left some lacuna. For example, when we talk about long cohabitation, what is the period?
What is the period?
Yes, what is the
because
period?
Then some people will say 1 month, 2 months is enough for me.
Yes. And again, another interesting thing about that judgment, it also talked about interdependent relationships, where parties, yes, are living together. We've stayed together for 2 years or more, or even 5, but we don't have intention of getting married. And they were quoting countries like Canada, where they have a legislation dealing with this relationship, where maybe you've been divorced before, you've been in other marriages, but now you're getting to a new relationship with no intention of getting married. So Supreme Court is something they say courts have to use it very sparingly when they are conferring such marriages, but it didn't really abolish it at all. It actually gave it some life. Because when most courts, when they were interpreting the 2014 Act, which brought the aspect of registration of marriages, it was somehow dying.
People are listening to you now.
Yes.
That's why I said that you really have to tread carefully then in this, when you're really trying to interpret what the courts have done. From what you said, Marcy, has it made it easier for you in this particular space to listen to cases pertaining divorce, or it's made it a bit more complicated? How do you judge intention? How do you judge that somebody really wanted to get married to somebody? How do you judge that they were married? What are you looking at?
Of course, it has created a lot. There is also what is the measure of measure some issues in things like intention, but the parties, of course, they've said is intention. You know, there's some things you cannot. You'll say intention, like this person really didn't intend, but it's because presumption of marriage is more implied. Maybe there's some things. Of course, it is going to be hard to be proven things like intention, but the contact of the other party might create the intention. Yes, maybe the contact that you went to the parents, you are visiting the parents, you people have like 3 children, he has been paying school fees. You know, even there's a judgment where the judge was like, even when parties get together and you as a man, you've been paying school fees, you've even bought property where both you've taken loan and you're acting as if you're contributing to build a home. You understand? So, of course, there's that lack of now understanding what is this intention, but of course what we'll appreciate with the Supreme Court is it went ahead at least to lay out what has to be met for courts to presume such marriages and how courts should interpret it. Yes.
But when we go back to the ruling before this, that essentially say that if you stay with somebody for 6 months, that person could essentially claim that you are in a relationship. When you go back and look at that ruling, what were the disadvantages from a legal perspective that you look back and say, yes, we lacked something in this? And then could you say that we haven't really figured out the Marriage Act completely, Marcy, if you're saying, yes, a ruling could be made, stays for 1 year, and then a year later we're saying, well, let's relook that because of ABCD. Are we expecting this again to change?
First, what we'll say is when you have a look at the judgment, you'll realize it was based on when the matter was being instituted, it was before the new Marriage Act. That was in 2010. And the law that is applicable by that time, it is the old Marriage Act, which of course it is not so different with our current Marriage Act, but our current Marriage Act has introduced very many elements because when you look at section 96 of the new the Marriage Act 2014, it introduces the issue of registration. So when a marriage, even if you're saying come we stay and you've not gone to register, it's unregistered. So that is the thing that we as practitioners is something we thought Supreme Court will maybe, of course they were restricted by what been it's an appeal, what was raised, but we thought it will at least touch on issues of registration of marriage and place of can we stay when the Act requires that all people it was I think 3 years, 4 years after the enactment of the Act that all marriages must be registered. So we wanted at least some enlightenment on that aspect. So that's one thing maybe we could say that was not fully addressed. But of course, at least again, I will say with where the society is, the Supreme Court was also trying to cure some injustices that may be caused to some parties. For example, take our parents or some of our relatives who we know they've stayed with someone for over 20 years. They have children, but they've never gotten married. The man has never paid dowry. There's no any marriage certificate. They don't know whether there's even a thing like registration. Then what happens to those parties? How should law cure them?
which is essentially what was going, by the way.
Yes.
Your people, and that question stems from that some traditions that the law essentially doesn't give weight as would again be taking center stage when it comes to relationships in the country. I mean, if you go to my community as well, I don't think that even registration would essentially be heavy for two people who really decided to come together. And I know of couples who stay together for 20 years plus. If they come to court for a divorce proceeding, you as a judge or you as a law practitioner, indeed, when you're looking at this particular case, you will rule them out as not husband and wife, going by the fact that they have not been registered.
Yeah.
If you're essentially going to rely on the 2014 Act, does it make it complicated from that sense as well?
Yeah, it makes it complicated, and I think when the Supreme Court is trying to give the elements,
yes,
because you realize a couple who has stayed for that long, they will meet most of the elements.
Definitely.
Yes, they will call witnesses who will testify that these people have been living together. Yes,
yeah.
Then issue. But one thing also people need to understand is there's something like capacity, which is the key thing. Which even when you look at that judgment, the reason why it was held that there was no presumption of marriage,
yes,
there was no marriage at all, is because of capacity. So even if you stay with someone for over 20 years, and that person doesn't have capacity, by capacity I mean maybe they were married under monogamous marriage, they were previously married, and it's not in a potentially polygamous type of setup. So that party doesn't have capacity to contact. So inferring again common law upon them or a presumption of marriage then becomes problematic in that essence. Yeah. So again, those elements, that's why the Supreme Court is also insisting of the issue of consent and issue of capacity, which is the key thing, capacity. Yes. So even if you're coming to stay with someone, make sure they are divorced, make sure they have their papers right.
Yeah.
Yes, and we have very landmark matters that have also we've seen. Even people we know, famous people, that this was not a wife because this person did not divorce before. Yes, they gave you papers, you saw the papers, but where is the decree that he was divorced? So capacity is a big thing that they were insisting. And also, again, what people should not mistake is that the things like mere friendship or situation where you just side chick or something like that. It's not situationship.
It's not recognized by law.
Yes, it's not. Actually, what Supreme Court was trying to say about interdependent relationship, they were trying to, of course, the society has changed and where we are at the moment. So such things are mere situationship, as you refer to it. It is not something you'll be moving to court to infer presumption of marriage upon.
Yes.
Yes.
Does the law operate in, for lack of a better word, because I'm a journalist trying to understand exactly how you perceive law, in black and white terms, that this is what the law states, so it's got to be like that?
Yes. Or
does it look into how this environment that this particular act has to operate in? Because then, once that law, that ruling was made, people all of a sudden woke up. They said, wow, does that change everything in how we do, we cohabit in relationships? Because there's even the promise to marry. The people have been together for 3, 4, 5 years, and it's actually given, saying that we are working to when we get married. Because the definition of marriage, again, I don't know how law perceives it, it's a process, something that you gotta be ready for. Does it mean that in the process of getting married, as you're trying to build to marriage, this law now, this ruling comes in and says, no, we don't recognize that. But in a society, the process for marriage is a process that is respected by religion, by tradition, and by practice, Marcy.
Yeah.
Does the law now say, you stay together for 3, 4 years, building towards marriage, if it fails, you can't go anywhere. You have to go back and wipe your tears and say it didn't work. Is that what it is?
Essentially, is if you are unable to meet the elements and to prove that that's a marriage, like something that court should presume as a marriage, because even the Supreme Court is saying, of course, we should not be encouraging that type of marriages. Like court should tread very carefully and sparingly Actually, the word being used is sparingly.
Sparingly.
Yes.
When they're making judgments on these cases.
Yes, because of course parties have other avenues of doing marriages. And one thing I have to say is that promissory to marry is not a marriage at all. It's just a promise. And there's of course a judgment that I saw for Uganda, which of course it awarded someone for the cost of maybe because one of the parties had paid school fees, but it was very different from a marriage perspective, because that person was seeking damages for all the money as used on this lady they were promising to get married. But in our laws, promissory to marry is not a marriage. It is very clear, it is stated. So sometimes the law, it is what it is. Where our statutes have expressly stated about a doctrine or a principle, it is of course it has to be applied as it is. Yes, and of course we are borrowing presumption of marriage, of course, from, it's a common law doctrine to us. So, of course, that's why maybe because we need to use it sparingly, because now we have our own laws that are governing marriages, and it's good. We also encourage people to obey our laws and to also do things as per the book. But, of course, it doesn't close to a situation where, of course, as a society we are growing and people are not more into marriages. We also have to accept that there's some people who someone will just stay with you, but they're not so sure if you're the person they need to marry, and you've acquired property together, or you've contributed in a certain way towards acquiring that property. So how do we divide such properties? Yes.
In the wake of this new ruling by the court, are we going to see a change in how people now approach relationships? Because we don't understand, if I'm saying that the common practice is let's build towards a marriage before we get there, are we not going to see where people are going to have to register to be in a marriage if indeed this law then is in operation within the country, Martin?
I think we are going to see more work people, because because
we're going to be more work people, or marriages that are going to be stopped.
No, right now I think with the judgments that came in, we are going to see parties building to more proving what they've contributed. If, for example, if I'm doing ABCD, I'll keep my receipts, or I'll do, it's going to be a bit different. And I think parties are going to be a bit like, if you're staying together, maybe push the other party, like we need to do the traditional wedding. If it's not the traditional wedding, can we go and approach, we register, or do a civil wedding? So I think it's enlightenment to the public, and people have been in such situation to be more woke, because, for example, I've helped you maybe build yourself to this level, and have contributed ABCD, and I know I'll work with nothing. Of course, I think it's a good judgment, and it's more enlightening to the public, and public are going to be more aware.
Yes.
Yes.
In majority of in majority of the rulings that lead then to the changing of the law in exactly how we look at it, this is going to be a landmark site in how we're going to look at it. We're going to always go back to, in the ruling in a 2022, so and so versus so and so, the court ruled about A, B, C, D. But if you go back to this particular case, again, it was based on a property dispute upon divorce proceedings. Does that change it? Given that, Marcy, even as we say, let's look at it, with a soft heart. Don't just go in and say the law it is and this is exactly what it is. That's what the courts really want you to do when you're applying this law. It's not going to change it, because whether you like it or not, this particular ruling on marriages, when you look into issues of tradition, culture now, just the way we relate and cohabit with in the modern culture, is that going to keep on changing? That's the question that I want you to respond to, because we're going to look at it and then say, maybe this one does lack in A, B, C, D. Do you anticipate that this one is going to change as well?
What we're anticipating is, first, we're looking forward to see first, because there's some recommendation that Supreme Court made.
Yes.
So Supreme Court made some recommendation to, of course, the legislators and the Attorney General, for them to see how it can be incorporated. Either is it for example, of course, I recommend that an extra section was added to our Marriage Act. You see, we're even looking as far as our country. Of course, this is a problem we have, it's a global problem. We have even well-established countries that have not yet dealt with the issue of where parties just stay together without a formal way of doing a marriage, but it's a marriage.
But it's a marriage, isn't it?
Yes.
And both of them are comfortable with that.
Yes. And they call each other husband and wife. Yes.
Let's bring up a family. Let's find a way of this working out together between the two of us?
Yes. So we are looking to see what recommendation the AG will make, being the government advisor,
yes,
and what if any legislation move will be made, because look at our country, our neighboring country like Tanzania. It has a well-defined, it has included it in their law, and they say any party will stay for 2 years, and there's that long cohabitation, that's a marriage. First, for them, they've already incorporated it in the act. So for them, they've already dealt with the issue, because it's a societal problem, our current societal problem, which is even likely to come in future. So I think we are looking forward to see maybe within a year or 2 years how our legislators will look at the issue because of those recommendations made. And also, I'm also looking forward to see about interdependent relationships, because they also wanted, they also made a recommendation of that quoting country like Canada that already has a legislation dealing with relationships where people are just staying together but they don't want to get married. And what are the rights that confer, or what rights can be acquired in such situations.
Yeah, pretty much, because we got to figure that out as well.
Yeah,
so we're going for developments on this particular ruling as well. Once the consultative parties then will look into what the High Court really wanted them to look into this issue, isn't it?
Yes.
Final question on this before we take a break and then come back and look at another bigger aspect as well, by the way, that has been a proponent of even the previous House on property distribution. Is it a common scenario where you have laws like this, especially ones that are touching on tradition and culture, because marriage is a cultural issue? Is it a common scenario where you will see them change over and over again? And with this current ruling, does it sort of punch holes into the previous ruling? Because even that particular ruling was also stating a particular case, and the court was also informed when they were making that particular ruling, which somebody said, are you reading prejudice into any ruling touching on marriage cases? Because it will depend on who has looked into the case. Yes,
of course, one problem we have, judges are different. Judges are informed. Of course, as much as they are guided by the law, you'll find one judge ruling this one, the other one interpreting law in this way. And this, of course, we always have that Pandora box of how will this one interpret. And prior to this matter being taken to Supreme Court, we were having different judges. This judge will say there's no presumption of marriage, because there's even a recent judgment that had come that there's no presumption of marriage by virtue of that issue. You must register marriage, and the marriages that are recognized by our Marriage Act. Because when you look at this type of marriage, you realize it's not recognized by our Marriage Act. We just confine it by common law and Evidence Act. Yes. So, of course, the judgments have been varying from one court to another. We've never had like this is the equilibrium, this is how the presumption of marriage should be. Yes, and courts were even moving. And even we remember when we were in school, that was a debate, because this one is saying this, you're using this act, you're trying to argue this, you're getting a judgment, you're backing your case. And that's why I think court is like circumstances of the case. Because one thing about cases is, so every circumstance is different. Just hire you a lawyer, you might win.
or lose it, isn't it?
Or lose it. So, of course, that is good, something. But, of course, Supreme Court being from the hierarchy, being the highest court, of course, it forms the precedent. All the other courts are bound by what the Supreme Court has said. But remember, as I told you, the court still left the discretion to other courts. And also, there's no, the analysis of the matter is special in its circumstance. That's why they also court are like
let's look at this particular case independently.
Yes, and which all cases should be looked at that way, because, for example, as I told you, that matter was being dealt using the old Marriage Act. Of course, you'll not expect when someone comes to court using the current Marriage Act for it to be applied the same. So maybe what we can say Supreme Court did that is best when it comes to Can We Stay is just giving the elements and laying this is the layout that must be met for a presumption of marriage to be upheld. And also advising judges to look at those cases sparingly, isn't it? All right. Now, the other question that I want you to touch on once we come from this break, because we're going to get into the other conversation as well on property distribution. There are guys who asked, I was married under the 1995 Marriage Act. I was given a certificate. Good. I'm still together with my significant other.
I'm not ruling out a divorce proceeding anytime, because these things do happen. Doesn't mean then that I have to go relook that act and get another certificate that essentially reads Marriage Act of 2014. Common issues that are now rising from some of you who spoke to us yesterday. Do not worry, Mercy is here with us. That's exactly how we're going to open. And then once we come back now, there's the other bigger elephant in the room. It's not going to be 50-50. If you get divorced, there's another clause that has been introduced. Let's talk about it right here on Lookuptv. My name is Simba, Elijah Charles Kiage. We are online at Lookuptv across all your social media platforms. By the way, even on our website, we are currently live there, www.lookuptv.co.ke. Once we come back, let's talk about the new clauses in the Marriage Act of what? 2014. See, sometimes we get it wrong. And they say, after the first part of a conversation, if you have been listening to Mercy and I, it's not that the court says, come we stay is not a thing. No. Guys, continue. But just as you continue, the court then is saying that even in this come we stay, what are the elements that you have to meet? Mercy calls it capacity. For you to claim, when we're doing come we stay with this particular individual, we were essentially husband and wife. That's why the court said, let's remove the period, 6 months, could be even 10 years if you wanted to stay together, come we stay. But then, do you meet the capacity? Can you prove in front of a court of law that so-and-so, indeed during that time, was my wife or husband? That's not the only ruling, indeed, that again we're introducing in the Marriage Act of 2014, because there's another case as well. Now I'm going to introduce like this. In the case of Joseph Ombogi Ogetonto, who sought to overturn a decision by the Court of Appeal that ordered the matrimonial property and rental units in the property be shared equally between himself and his estranged wife, Mother Posibori Ogetonto. Now, I want you to listen to the phrasing of that. It says this lady, again, your mother, has the name of Ogetonto. Now, this introduces then the next part of our conversation, where the court said, it's not going to be 50-50%. Again, the interpretation that we got from there might have been essentially wrong, because we go then back to what we've seen in the national proceedings, National House proceedings, the conversation of whether indeed somebody should get 50-50 is based on contribution. And if indeed then this person is your wife and husband as well, takes us back to the other ruling as well. Do you meet that capacity? Good. But just before we get there, Mercy, welcome back to the conversation.
Oh, thank you.
There is a question that you were dealing with, that some people you see here now, like Ogetonto, before he went to court, was married under the Abakusi customary law in the 1990, which was essentially well recognized in the Marriage Act of 1995.
Yeah.
All the way back to 2014, now that majority of this will not really stand water in the new law. So people are asking, should we go get new certificates in that case, if indeed you have a certificate that reads Marriage Act of 1995, Simba Elijah Kiage is married to so-and-so.
Of course, in that situation, of course you're married because you have a certificate, and of course for customary marriages, our Section 6 of Marriage Act recognizes such marriages.
Yes.
But of course you must meet all elements. For example, when you look at the Kikuyu marriages, all the 3 stages must be done, and if parties wish, they must obtain a marriage certificate. You can go to the AG's office and obtain it. Also our marriage, we also have to be recognizant of our Marriage Act, Section 96, I guess 3, that requires that all marriages, after it gave the AG was to issue a notice, and after 3 years, there was a leeway of 3 years or 4 years, that marriages should be registered. So, of course, in the current situation, we'll expect even all those marriages, someone to get a certificate. But I think courts will not, of course, for example, someone who has a marriage certificate will not say there was no marriage because already there's a marriage. Of course, what they maybe will not meet, yes, of which I think a lot of people, the public maybe might not be aware, is that requirement of maybe to get a new to register those marriages if not registered.
Yes.
Yeah, that is something that maybe we need to do more sensitization to the members of the public. But of course, if it's a customary marriage, if you're able to prove all the elements, dowry was paid, all the stages depending on your customs have been met, of course there's a marriage.
Yes.
And of course, before we reach to any matrimonial division, of course a marriage has to be established.
Yes.
Yeah, and I think that's why in other case, the one that we were discussing before, it was dealt different when courts found out there's no marriage. Yes.
Pretty much.
Yeah.
Good. Let's jump into this second ruling then. That is between Joseph Ombogio Getonto and Mother Posiborio Getonto, which essentially meant the courts also look at that particular ruling in general. Now, this is exactly what they said, that the Supreme Court of Kenya ruled that spouses are not entitled to 50-50 share of matrimonial assets after divorce. Now, this is what they said. The court says distribution of property is based solely on individual contributions. Mercy, does that make it the hardest job for any judge on the face of the planet to actually prove that within 10 years, Simba, this is exactly what you brought to this marriage? Are we asking spouses now to start taking stock of whatever it is you bring to the marriage today?
Oh, rather, it's of course going to open such boxes, because I'm so sure now parties to marriages will be very woke. You'll be making sure you keep receipt. If I buy a packet of cement, I'm going to keep that receipt because you never know. Yeah, but one thing we have to point out is that that matter as well,
yes,
was also being decided using the Matrimonial Women Property Act of 1882,
yes,
which is our old act. We have the Matrimonial Property Act of 2013, and I think if we were to rely on the current law, a lot of things, our current law, even for them, they also, we recognize contribution as monetary and non-monetary. So
and that's where the debate begins.
Yes, that's where the debate begins.
In fact, if you go back to the National House, when they're trying to come up with this particular law, now the courts are also winning on it differently, isn't it? That's where the debate begins. What does it say?
Again, you know, this is not new to us. As as legal practitioners, it's not, because
then you're missing this.
Yeah, that's our so like a daily work.
Yeah.
So what one thing we have to be very cognizant about is our marriage, not our Marriage Act, Matrimonial Property Act Section 3 already defines, when dealing with what is contribution, it gives the what is contribution, farm work, for example, taking care of business premises of the family, domestic work. Those are non-monetary contribution, but are well recognized by our law. So of course, as I was telling you, cases are decided on the facts presented, and cases are different. So the scenario at hand might have been different with what is, if someone else was to file today and say, I've been staying at home, this is the farm I've been taking care of, this is what I've been doing, and that, if you even look at that judgment, court goes, and even the final judgment, final verdict was at 50-50, if you peruse up to the final part, 50-50, because this man took loan to pay that mortgage, but also the lady was paying school fees. So what happens to this party who is taking care of all the children so that you can acquire property? Should court turn a blind eye and say you didn't contribute? Because essentially, me taking care of other elements of our well-being as a family is what has enabled you to acquire that property. If I wasn't paying school fees, it means the money you're getting should have been used there. Yeah, so one thing we have to consider is that even all the decisions we have, courts are very fair, and courts have always looked at other forms of contribution. We have the monetary and non-monetary. Of course, it will not entitle, most of the time it will not entitle you 50-50, but at least you will get a share.
Is that what I'm saying? That at least you're going to get a share.
Yes, at least you're going to get a share for doing other work, like taking care of children at home.
How do you then? And that was the biggest debate in the National House when this particular one was fronted. And by the way, raised a lot of conversations in the National House. We didn't know the National House is, male dominated, and we saw how it went through. Didn't even need to debate on it. When the speaker read it, everybody voted on it. It cannot be 50-50, and it passed like that. But you see now the Supreme Court has made a ruling on it. That is, yes, even under common sense, cannot be 50-50. But then, is it going to be very difficult for the court to try and value what non-monetary contribution is? Is that where it starts? Do we leave it to the lawyers to decide this case?
You don't even leave it to the lawyers, but the judges, because at the end of the day, it's their discretion to know what percentage I'm awarding, like whether I'm going to just give you 30% of whatever interest you...
Depending on, is it going to be based on your story?
Yeah, based on your story. And of course, the main challenge you've always faced is, how do you value, like you cannot give a monetary value to, for example, domestic work and management of home, which is defined as contribution.
Yes.
Of course, we always have that challenge, and I think even being, when you're at the judge, if you're the judge, of course you'll have that issue, but I think they've dealt with the issue very well, because most of the time parties will not work with nothing, as long as you're able to show that and the things that you are taking care. So we can say it's progressive. Let's give it progressive until when we can maybe define, because of course if 50-50 will also be prejudicing the other party, because you'll find some situation where both of you work, and maybe at the same time as we work, I've used my own money like 100% to buy that property. Yes. I've acquired it individually and not together, and you've not contributed to anything. So I think when courts want it to be looked at contribution basis, then it's also to safeguard all parties on their right to own property, because even the Constitution, as much as you have the right to own, you as a spouse, you have other rights. Also as an individual, you have your own rights to own property.
Yes.
Yes, so I think courts are they usually look at the circumstances very well to know what, when dividing property, when dividing matrimonial property.
Yes.
Yes.
It's interesting you're saying that it's actually a developing issue, because let me throw you back to the ruling, or just the commentary. It's actually a commentary besides a ruling. That is according to Justice Teresia Madeka. Yes. Again, but towards the end of 2022, who said, listen, we gotta stop talking about domestic work as actual work in a marriage. Because she said, being a housewife is a 24/7 type of a job, and she said but is one of the only jobs that doesn't come with a salary. Now, from cooking, this is her, cleaning and taking care of families, housewives carry most of the workload at home. And she said their efforts are not compensated and are usually seen as mommy duty. She did say on the sidelines of a ruling that maybe under the Marriage Act, it's time for us to start considering this as actual work, which essentially then leads into the conversation of whether you like it or not, is it going to be 50-50? Because you can't talk about being a husband and a wife, running a family, if you're not going to consider that being as a 50-50 relationship. Is that what makes this law then be one that you're calling it will develop, definitely?
Yeah, I think it will, because as you've seen that judgment, I remember even she was quoting that the fact that you pay a house help or a house manager to help in those duties, then you don't want to quantify or to call it contribution for the ladies. Of course, problematic in its nature. And of course that is a progressive way of looking at it. And again, although it also creates its own problem, because again, it's also taking care of your children duty. Because it's a responsibility automatically for the both of you in that relationship. Yeah, but again, we also have to look at those parties where parties get to a marriage, and one party is convinced, the other party convinces the other that you have to stay home and take care of our family, as I maybe become the provider. And remember, of course, you have to acknowledge, as much as they're not giving the monetary contribution
Yes.
or bringing some money to the table.
Yes.
They're doing things to enable you acquire whatever you acquire.
It.
So I think what courts try to be really fair, and that's why I started, try to be fair. In that scenario, they might not give you 50, but of course courts have to look at the circumstances and to what you are performing. If you are a housewife and you are busy, like look at those who stay in a country. You're in the farm all day. You have crops, you have animals, you have you have to take care of a lot in that home. So do you just say that person to work with nothing? Remember, they've invested their time, their effort. So it is something, as much as you can't quantify, and some even family businesses. So I think it's very clear, and courts have always taken the better approach. And our act, the 2013 Act, I think it is very fair trying to quantify such things. So of course, we will want to also know, us addressing what is the place of a housewife in regard to our laws, and when it comes to division of property, where do they lie? Yes, of course, we've tried to state some of the things they do, like work. There's of course someone who just stays home doing nothing. So do we also assume they've contributed to anything? There's of course that.
Have you ever run into cases where the court is put at task to evaluate moral contribution in the success of the enterprise, which is the marriage?
Yes, those are normal situation you face when it comes to division, most of the time when there's no monetary contribution.
Yes,
it's something, because as we've said, even what Honorable Justice Mateko was try to bring to light is now that person who just taking even care of children who are going to school. I wake up in the morning, prepare them, have to make sure they've done homework, all those things. Do I work with nothing from the marriage when it goes south?
In these rulings, now I'm asking you direct questions that we've seen that came out from the poster then that we floated. In fact, let me ask this one after I ask you this. Then somebody said, if you look at the rulings that the court is making, the court is just advising all the lawyers and the judges who are going to make decisions on divorce proceedings in the country that please apply the law per the case that you have been presented with. Yes, this is the law. This is what your guideline is going to be, but applied on per case basis. Somebody asked a very interesting question. If everybody now is going to then start taking stock, where the court is saying it's not going to be 50-50, we're going to look at your contribution, are we advising couples before they get into marriages to sign prenups and then say, because we don't want to go to court and start tussling over what your moral contribution is going to bring to this marriage? Because the men will also say, well, you can't also say that I didn't morally contribute to this marriage. I did contribute as well. Are we advising couples now, please, if you can, because of this development under the Marriage Act of 2014, it's time for you to start signing prenups before you marry?
Of course, you cannot preempt how parties are going to to react and other measures to be taken. But of course, the prenup thing is of course a good cure for those people who feel they need to protect their property.
Yes.
Of course, we can add that contract that maybe what I acquired before, you will not get a share. What I've acquired during the marriage, you can only get this share if you say this. Of course, we will agree the terms as long as it's not coercive and you've agreed willingly. Because of course, now that becomes a contract that you've agreed between parties and you've willingly signed.
And it's recognized under this act.
Yes, you easily. But of course, again, it will also bring problems. First, you must, maybe what we might lay out for parties who will want to take that route is make sure you get an independent advice and get a lawyer. Because there's some things you bargain for yourself that are not favorable at all until you get a professional opinion. So, for example, if you're getting married and you're going to be out, so why will you be signing a prenup during the marriage and you know you'll be staying at home where you get nothing? You see, or at least make sure what you're negotiating as parties is also favorable for this person who will be doing maybe a monetary contribution.
Yes.
Yeah. So maybe for parties who will want to take that approach, my advice will be make sure you get a professional advice before committing yourself to that, or do proper research before, because I've seen scenario where you just brought some papers at home, later you talk, oh, sign there, sign here, sign here, you're just doing your normal duties, you end up signing a document that you're not even aware what you
You've
signing
signed
yourself to. So it is good you parties to act from a point of information and also to make sure they safeguard their interests. Of course, I know with where we are right now since 2014, since coming in force of these acts, I know parties are more woke now. Even if you say I buy, maybe give you some, I take a loan, I must of course keep receipts. You know the society we are living in,
yes.
and also our generation.
I know.
So of course, as parties, it's also it's good as much as you should enjoy the marriage. It's good also. If you are the vulnerable party, just keep receipts. If something, one day you have to be called to prove something, at least have something to prove.
So this is from Joseph Okenye in Kisi.
Yes.
And it's a very interesting question, Marcy.
Yeah.
And I don't know how it's going to sound, but since it was asked, let's just ask it. And he's watching from Kisi, said he will be watching this show today, just waiting for you to answer this question. Is it a common scenario that in most divorce proceedings, for any other person looking at it from outside inside, that we've seen that we feel that only one gender, which is the male gender, feels that they're always on the losing side, that they're the ones who are always fighting to retain their property, to hold back, not to be on the losing end? Is that something that the law has not essentially recognized? If that is a general feeling, even in international cases, local cases, you sort of tend to feel like, oh, come on, the man is really trying to fight very hard not to lose. Is that something that the law has not made clear? Is that a hole within the law if that is a general feeling?
First, I feel it's a very big misconception that the public has against our laws.
Yes.
When I look at the two, of course, when you look at the genesis, for us reaching to where we are, of course, it's because that before women used to be oppressed. Of course, it's when we developed the division of property until where we've reached. But when we talk about the current situation, our laws are very gender neutral. They serve both, regardless of where. When even the previous cases that we were discussing, who was the petitioner? A man. Saying there was a marriage, I need something divided. I need this divided as a matrimonial property. So when public tried to say that this is more favor of women, because that was initially you'll find most women were not in the workforce. But I'll tell you, for a matter of fact, most divorce matters that we've done, even to a point of matrimonial division, you find the ladies even having more than the men. Even you find the men now claiming from the lady. The lady has acquired more than the man.
Yes.
Yes, you have to acknowledge that the society is changing, and the place of a woman is also becoming different. Now we have women in workforce, even earning better income than the men.
Yes.
So, of course, we are even, I'm preempting a scenario where we'll see more men moving to court for the division rather than even, because we have even men who are stay home, the woman is the one who is providing. That is a scenario that happens in some homesteads. So I think when we look at the law that way, the law is always neutral, then you represent your case, and our courts are very fair nowadays. Even for example, children matters. People used to think it's automatically when the lady goes, custody, you the man will be taught to pay. No, courts are very fair, and they'll always look at both parties in those scenarios, whether a man or a woman. Because of course our Article 27, you should not be discriminated because of your gender.
Yes, yes.
Yes. So of course that misconception, I think with time it will go, because the scenario at the ground, and even that having the first case, the petitioner being a man who is claiming from the lady, that says it's different. So I think we just need to maybe embrace the law and move to court. Even if you're the man and you know, there's a scenario where you will not, you'll give the lady money to buy the property. You've contributed, but it's in your wife's name.
Yes.
Yeah. So don't shy off from moving the court, because our courts are very fair. They never discriminate when it comes to gender. And as I've told you, eventual matters that the person who is claiming contribution is a man.
Pretty much.
Yeah.
Whew. Marcy, thank you very much for coming.
Thank you.
Hopefully for all the people who've listened, it's not one way.
No.
That there is the understanding that you need to put into the law. So can we stay still here? I mean, even this particular case that has got you talking since last week about the 50-50 property, matrimonial property distribution, it ended up in 50-50. Think about it. So guys, for Marcy, get it registered, stay woke. That's the only thing she said. Yes, love your partner, come up with a family, but then stay woke. Marcy, quite lovely talking to you this morning.
Thank you for having me.
Take her back online at Lookuptv across all your social media platforms. I am Akian Gasimba Joseph. Thank you very much for watching us, and a lot of you who actually did send in those questions directly to me. I do appreciate. Let's keep on using that handle at Kian Gasimba at Lookuptv across all your social media platforms. Again, we take a tiny breather. Once we come back, Muguru, Ian, and I are going to take you online, see what it is that you're talking about, and tell you the biggest stories that we're going to bring you throughout right here on Lookuptv. Good morning.